My lords, we generated over lunch a machine translation of Judge Saltikova's 10th of November ruling from the 1st of November hearing. Which we provided to my learned friend. I wasn't going to say anything more at this stage. I can deal with it in reply if necessary.
Yes. Thank you very much. Yes, Mr. Hussain.
May it please the Court, my Lords, I'm proposing to deal with the three issues in their logical order: gateway, forum, and then final relief.
Yes.
On the first two issues, as you all know, we say the judge was right for the reasons he gave, and he could also have relied on the two additional matters we've referred to in our respondent's notice. On the third point, which I will be much shorter about, the short point is that the judge did not decide it. It's not part of any order appealed. The appropriate course, if your lordships were against me on the first two issues, would be to remit the question to the court below for further consideration.
Sorry, which question?
This is the final relief question. I do apologise, my lord. On that, if I could just prelude my submissions a little bit. What my learned friend was submitting to you was essentially that the court ought to proceed directly to consider the question of final relief, even though it wasn't any part of this appeal, because of this upcoming hearing on the 14th of February. And he suggested that in some way there might be, he even suggested it was likely at one point that the judgment on the substantive issues might be entered on the 14th of February. Now, the way in which the submission is made is slightly unsatisfactory from our purposes, because this is not the subject of any evidence that we have seen or that is before the court. But I have just seen just now the machine translation of what happened on the November, on the 10th of November. And if one looks at page 3 at the bottom of that, you can see what the decision is. And so there was a decision to suspend proceedings in this case until consideration of the dispute on the issue of an anti-claim injunction is considered by the Court of Appeal. So the court was clearly made aware of this hearing and is suspended on those grounds. And then, so far as the 14th of February is concerned, over the page, it says to schedule a court hearing on the issue of resuming proceedings in the case for 14th February, and then it gives the date and then says for 40 minutes. And I can only say this on instructions because, as I say, this is not something that's been put forward in the normal way in evidence before you. It is my understanding that the sole function of the upcoming 14th of February hearing is to consider that issue that is identified there, whether the suspension, the stay is kept in place or lifted. And that is the subject matter of the 40-minute hearing. I am further instructed, but I can only give this on instructions, that there is no risk that in some way the court is, at this hearing, convened for this purpose, going to proceed directly to giving a judgment on the substantive matters. And of course, when your lordships come to consider this question of whether you should proceed directly to look at final relief, assuming, of course, for these purposes, that it's necessary, the interim anti-suit injunction that Sir Nigel Teare made continues. It continues today. It will continue tomorrow. It continues pending resolution of the appeal. So my clients are prohibited from taking further steps, subject to the ability to oppose the dismissal. And there's no suggestion, or should not be, that they have acted contrary to that interim ASI that is in place. So there can't be any suggestion that in some way, if the court doesn't deal with the matter today or tomorrow, or at least before the 14th of February, that RCA is going to take some step that might lead to any form of substantive judgment being entered into, because, as I say, the interim ASI will be in place. And there simply is no material before you or evidence to suggest that, notwithstanding that, a judge in the arbitrage court on the 14th of February is simply going to enter judgment. The only other point that I wanted to make was that there was some intimation, if not assertion, that RCA had in some way acted contrary to the interim ASI, and it was suggested that they had done so by submitting additional documents to the court. Now, again, I can only give you what I'm instructed is the case. What I'm instructed is that, as your lordships may know, the interim ASI did not prohibit all action. It permitted expressly opposing the bank's application for dismissal of the proceedings in Russia. And I am instructed that the material that was provided was for that purpose only and was not in contravention of any interim ASI. And as my learned friend fairly acknowledged, there hasn't been any formal assertion before these courts that there was such. So well, that is what I wanted to say about that document. If I can return then to my proposed order.
You're coming back to the question of final relief at the end, are you?
I will, although, as I've indicated, it will be brief, not least for
fine.
timing constraints.
I mean, the judgment below does say in paragraph 1, this is the trial of an action for final anti-suit relief. Now, you decided in your favour on the points about gateway and forum, so you never got to it. But it wasn't an interlocutory hearing, it was a final hearing.
Indeed, your lordship is right that there was the application for final relief, and the judge was the judge had quite detailed submissions about whether or not final relief should be granted in this case. Now, those submissions have not been canvassed before this court, but your lordship is right that the bank was seeking final relief at the hearing before.
And any evidence would have been put in for that hearing then?
So
It's not
yes,
a case of you
there
haven't had
was.
the chance to put in evidence. You knew that whatever evidence you needed to put in would have to be put in before the final hearing before Sir Nigel Teare.
Yes, my lord. Subject only to this, that it was an expedited hearing, very expedited.
That often happens in employment matters and speedy trials.
Indeed. So there were limits on the ability that RCA had to respond to some of these matters. But at any rate, so far as Sir Nigel's order is concerned, the only order is in respect of the interlocutory.
No, I understand that. That's because you won on the main point, but it was actually the hearing of the final injunction claim. Yeah.
Your lordship's right. Yeah. So,
But I mean, it could have been looked at in one of two ways. Either this is just an interim hearing and Mr. Houseman only had to show a good arguable case on the matters in issue, or this is a final hearing and he's got to show that he's right as opposed to wrong. I don't see what would have been left to a final hearing.
my lord, it's covered in. I can give your lordships the reference to it. It's covered in B pages bundle B 422 to B 427, and there are three arguments that were advanced that would arise in the event that final relief was being sought. And those arguments depended to some degree on expert evidence that was disputed, and those issues are not before you. And so that really is the argument that has not been had before this court. So to be clear, RCA was submitting and does submit that there is a separate stage once one has got over the threshold of interim ASI, in order to determine whether or not it is appropriate to exercise the discretion to make a final mandatory ASI. And I can't do better than refer you to those passages where the various points were set out. But what you can see from a glance at them is that they depend to some degree on issues of French law. So they depend, there was a difference between the experts as to the approach that the French court would take in recognising or enforcing an ASI. That had not been resolved, and we said would need to be considered for the purposes of considering final relief. There were also issues about the Article 11 and what the implications would be of the English court ordering final ASI relief in circumstances where Article 11 would be relied on in the French proceedings. And then there's a question of sufficient connection, which was the third point. And to be frank, my lords, I'm not in a position to go through all of those in the time today, not least because they depend on evidence, not all of which is before your lordships in the bundle. But that just gives your lordships a flavour that there were substantive arguments that were being advanced that essentially the judge never got to because they didn't arise, that we say it would be appropriate to remit to the commercial court if your lordships were minded to grant an interim ASI.
But it has always been the appellant's position that if we were with them on jurisdiction, this court should grant an injunction, a final injunction. That's clear from their appellant's notice.
Yes, it has been.
Yeah.
So, my lords, in terms of the way I'm going to structure my submissions, I'm perhaps going to take a slightly different approach from my own friend, which is I'm going to go straight to ENCA, and I'm going to show you what the test is. And I am going to approach it by reference to the various criticisms that are made of Sir Nigel Teare's reasoning in his judgment, and look at them one by one and see whether they stand up. Before I do go to ENCA, I did say straight to ENCA, and I have to apologise. There are always preliminary points, so if you can forgive me to make three of them. This is just to clear away some of the points that were made through my own friend's scouting arguments. First of all, the bank says that we are challenging the correctness of ENCA. And so it was pointed out that we reserve our position. Of course, we do so in case this goes further. We're not challenging the correctness of ENCA before your lordships. It was said in their reply skeleton that we were trying to subvert the ratio of ENCA, and implicitly the judge was, and that what we're really saying is that ENCA's wrong. So I just have to be clear and say that is no part of my submission is suggesting that it's wrong. This appeal is about what ENCA means, and you are bound to apply it. The second point, and this is again a general point, is that the bank also submits that our position about governing law for the arbitral agreement allows an exception to swallow the rule. That's their reply skeleton, paragraph 18. And again, that's simply not right. So we accept that the main contract governing law will usually apply to the arbitral agreement. In the absence of an express specification, the starting inference that the court will draw is that the main contract law will apply to the arbitral agreement. No problem. The inference will only be negated in the circumstances identified in paragraph 170 Roman 6, which includes, of course, the curial law carve-out. And so the whole of the debate before your lordships is about that carve-out and how it applies. But that is hardly an exception swallowing the rule. The number of jurisdictions worldwide that have been identified through the course of the argument as potentially applying such a rule are I think, four in number.
So you say applying such a rule, what rule?
Forgive me, the rule that where the parties specify the law of the seats, then the governing law of the arbitral agreement will be that law. you have Sweden, Scotland, Brazil, and France. So the number of jurisdictions where, so far as we are aware, where this curial law carve-out exception may arise are really very limited in number. So on any view, this is not a case of the exception swallowing the rule. The third point is that we are concerned here, and it's common ground, and it was common ground before the judge, with implied choice. We are not concerned with express choice. There is no express specification of the governing law of the arbitral agreement, and that's relevant for the logical series of questions that have to be asked in going through the Anchor principles in paragraph 170. And finally, the position as to French law is common ground. And that is quite an important point when one comes to look at questions of intention. Because the position is common ground before the judge and is common ground as we understand it here. And could I just ask your lordships to have a look at the relevant bit of the judgment, which is at A100. Paragraph 15. So this is referring to RCA's submission and says, the law of the seat, this is picking it up third line, the law of the seat, which is French, and which provides that the French courts would regard the arbitration agreement as being subject to what its expert describes as French substantive rules applicable to international arbitration. This indeed appears to be common ground. So it's common ground between the experts that the French courts would apply French substantive rules applicable to international arbitration.
What does that mean? Sorry, Mr. Hussain. Does that mean the rules of procedure in the hearing are treated as part of French law? Or does it mean that the rules of law deciding whether or not the arbitration agreement is to be governed by French law rather than English law?
My understanding is that this is applicable to aspects, validity, scope, enforceability of the arbitral agreement. So this is not simply limited to matters of procedure, but is going to the sort of substantive questions that we would conventionally regard as being part of the law of the arbitral, the governing law of the arbitral agreement. And then if I could ask...
Are you saying then that the what Lord Justice Nugent said in Deutsche Bank, not after contested argument, is simply wrong? That the French, it's not that the French courts are hostile to anybody granting antecedent injunctions, it's just they don't do it themselves.
This is a distinct point your Lordship's asking me about, but yes, we accept that. We accept that there is not a philosophical objection by the French courts. So that there is an issue about whether the French courts would recognise and enforce an English ASR, but we accept that there is no philosophical objection. Now, my learned friend says that's when we get onto forum, my learned friend says that, well, that's a complete answer to any questions of comity. We say no, but I'll come on to that in due course. But paragraph, if your Lordship still have the judgment below, paragraph 16 is important as well, because what the judge did was to extract the bank's skeleton argument as to what the position was, and to summarise, again, emphasising that this was a matter to do with the matter of agreement. And again, we understand that that is the position before your Lordships as well.
I mean, your expert was in identical terms. Or,
yeah.
Yes. Mr. Kaminsky, I think.
Your Lordship's right. And then if we go on to the next
I'm
page.
sorry to be difficult, it's probably because it's not my area, and I'm finding the process of understanding the English challenging, so please bear with me. Paragraph 16.
Yes.
The experts agree, and I've got in my mind the rules of procedure, the rules deciding whether or not the arbitration agreement is English or French law, and the rules deciding whether or not the main agreement is French law. So I've got three things in my head when I'm approaching these, and if any of those are wrong, do tell me. But 16 says the experts agree that the French court apply a substantive rule of international law of arbitration. And I think, good, but to which of the three things does it apply? And I read on, it says, whereby the existence and effectiveness of the arbitration agreement is to be determined. I think, oh, that could straddle 2 and 3. And then I read on to say, in accordance with the parties' common intention.
To be clear, my understanding is that this, and I can show in due course the expert evidence that there was, but the expert evidence is that this is not some rule whereby the French court undertakes some examination of what the parties may or may not have intended by reference to how they express themselves. Rather, this is a rule that says that where there is an arbitration that is subject to the French curial law, then it is a mandatory rule that the principles of substantive international arbitration, as developed by the French courts, apply. And so the position is, any time you have a French seat specified in an arbitral agreement, that means you've got French curial law, and the consequence of that in France is that you have principles of substantive international law of arbitration being applied as the law of that arbitral agreement.
So the principles of international law are applied as part of French law, as if they've been incorporated and
yes.
switched from being the book called International Arbitration to the book called Principe Français.
Yes, my lord, and that was the next point that I was going to come on to, which comes out of the judgment, and again is common ground. Because paragraph 20, the judge says the content of French law is clear and is not in dispute. Again, just recapitulating the point. And paragraph 21 refers to the Dalla case in the Supreme Court. Because so far I've been making submissions to you about what the rule of French law is, but then it's an English law question. How do you characterise that rule? Do you characterise it as a rule of French law? And that is what the judge was referring to here. And I highlight the principle, the sentence at the end. The true analysis is that French law recognises transnational principles as potentially applicable to determine existence, validity and effectiveness, so that answers my Lord Justice's point, of an international arbitration agreement, such principles being part of French law. Now, there is no challenge to what Lord Mance said there. There is no ground of appeal that says, no, these are not to be regarded as French law. The judge was wrong to think it. And there could not be. It's been reaffirmed most recently in Kababji, and that is paragraph 89 of the Kababji decision at page 655, if your lordships wish to remind yourselves of that. And so there, at paragraph 89, it was observed as this is page 655 of the authorities bundle, as Lord Mance observed in Dalla, as the substantive rules of international arbitration which the French courts apply are rules of their own creation, the reality is that the French courts determine questions about the existence and validity of an international arbitration agreement by reference to French law, albeit rules of French law which differ from those applicable to domestic agreements. So this is, we are talking about a rule of French law. Now there's a difference between the parties about whether it matters that this is a different principle from domestic French law, or as they put it, national substantive contract law, domestic substantive contract law. So there's a difference between us about when you come to ENCA, as I promise I will do shortly, that is a distinction that one finds in the rules there. But that is the only difference between us in terms of the effect of French law, because because everything else is common ground, and there can be no argument that these principles are not part of French law. Now, with that, could I ask your lordships to go to page 587 of the authorities bundle, which is the paragraph 170 of the
Before we do that,
judgment.
can I just ask, do you mind if I ask just one last question?
Not at all.
about Paragraph 89,
Yes.
because even that isn't clear, because there could be ordinary French law, if you like, the law on the tort in France. There could be international law, which is part of French law, and it's a special part of French law. It's not French law derived from the equivalent of the French common law or the regulations of the Conseil d'État or anything else. It's just a recognition, as you have in some countries, that international principles are to be treated as incorporated into the domestic legal order, but they aren't part of the domestic legal order in the same way that a decree from the Élysée is part of the French legal order. The source and nature of it is different. It just becomes part of it, and that might be relevant to whether or not it is the ordinary law of France which applies to the arbitration agreement, or whether in relation to particular points, international rules which form part of the French order as well apply, or is that not something that you even think about?
I don't need, in my submission, I don't need to go there. Yeah. So my understanding, and certainly this has not been a point of dispute so far, is that there's no distinction to be drawn between certain aspects of the arbitration being governed by these principles and certain aspects being governed by other principles. It's just a wholesale incorporation of what the French courts regard as international substantive arbitration. But if one then goes to paragraph 170 of ENCA at page 587, and we have the 9 principles there. Now the judge observed that this summary of the principles was there, or clearly there, in order to assist first instance judges when they were presented with these kinds of arguments. And that must be right. This is a distillation of the test or the guide, call it what you will, that it is that the Supreme Court intends other courts will be able to look at and follow without difficulty. And we say that when you come to look at 170, to a large degree, paragraph 170 is all you need in order to resolve the gateway question. In no small part, because paragraph 170 was clearly written, intended to be a guide to be followed without having to, as it were, reinvent what might be behind it. Now, having said that, I'm certainly not going to stick at paragraph 170 and say, take it or leave it. I will have a look at some of the underlying reasoning, but I'm going to do so principally in order to rebut some of the arguments on the appeal that are made. And so just going through that, first of all, we have principle 1, which is that we're applying English common law rules. We agree with that. There's no issue there. Principle 2 is that essentially you've got 2 categories. You've got choice, and then you've got applying rule of law. And so choice is A, the law chosen by the parties, and then if you haven't got choice or you can't reach a conclusion about it, then it's close connection. And for our purposes, we are mostly concerned with implied choice, but as you'll see, our second respondent's notice point also deals with close connection. And then we get on to 3. And so this is now talking about choice. And where the parties have agreed on a choice of law to govern the whether the parties have agreed on a choice of law to govern the arbitration agreement is ascertained by construing the arbitration agreement and the contract contained in it as a whole, applying the rules of contractual interpretation. And so there is a point of agreement between the parties, because we agree that what your lordships are concerned with here when you're talking about choice is ordinary contractual interpretation. To underline the point, there's no special rule of interpretation that's said to apply to arbitral agreements. It is the objective determination of the parties' intentions. But what you have here is a comprehensive and authoritative guide as to how their lordships expect that process of contractual construction will be operated in the specific context. Your lordships may say, well, how come we both agree on both sides of the court about this issue? And we say that the bank has rather lost sight of the fact that we're talking about what is a guide as to how to apply ordinary contractual construction. Because the various distinctions that the bank seeks to make in order to read down later parts, where it's saying it must be a statute, must be domestic law, must be a direct link, and so on. Those are admittedly distinctions of form, but then they don't respect the fact that the aim of the exercise is looking at objective intention. But I'm getting slightly ahead of myself. If we then go to 4, where the law applicable to the arbitration agreement is not specified, and you should see that. So that's the general inference that will apply in the majority of cases, perhaps the vast majority of cases, where the choice of the main contract law will generally apply to an arbitration agreement. And of course, we accept that that's probably going to be the most common situation, because as the court observes, it's quite rare for the governing law of the arbitral agreement itself to be specified. So what you're dealing with here is a situation where the governing law of the main contract is specified, but there is no express clause specifying the law of the arbitration agreement in terms. And that is what is required in order to come within Principle 3. And so and one sees, for example, that where the court in its reasoning refers to the typical clause is described as a clause that says this agreement shall be governed by the law of England and Wales. And of course, one obvious point that one can make from that is, well, if it's capital A agreement, and the capital A agreement includes the arbitration clause, then that might lead to an inference that the parties have intended to include it. But what the guidance that we're given in ENCA, and this is important, is that is not, for the purposes of the ENCA test, an express choice. Unless you have something that specifies the the governing law of the arbitration agreement, then you are in the realms of implied choice. And the reason why it matters is that we are now at the stage of the ENCA guidelines from 4 through to 6, where we are talking about how do you go about arriving at an implied choice. And the premise that is satisfied before you get into that is that you already have some form of typical standard form governing law wording that says this contract or this agreement is governed by English law. And so that is your premise, and what we then have are the circumstances where the Supreme Court consider that the main contract law inference, if I can put it that way, may be rebutted. And if you look at 5, the choice of a different country as the seat is not without more sufficient to negate an inference. So it's not saying choice of seat is irrelevant, but it's saying if all you've got is choice of seat, that is not good enough. And of course, we do not say that choice of seat per se is what carries this into a different category. Instead, what you then have is there's something more that is required, is set out in Roman 6. And I know that your lordships have pored over this, and as you can see, it's covering 2 matters, the curial law carve-out and the validation principle. And so what is being said here is, well, you may have a clause that says the governing law of this agreement is English law, but the arbitration clause may say France. Sorry, the seat is France. If so, sorry, that's not good enough. But if what happens is that you are falling within the curial law carve-out or the validation principle, then you may well find that starting inference is negative, and there is a positive inference that in fact the parties were choosing some different law as the governing law of the arbitral agreement. And that is and so it is, but the starting position is that you've got one of these typical agreements that my learned friend says, well, if you look at these agreements, that they clearly encompass the arbitration clause, and therefore that you must be looking at some very exceptional sort of radical thing in order to rebut the presumption. But that is not what is said in 6. What is said in 6 is simply that if the curial law carve-out is engaged, then the implied choice may be different. And of course, one is looking at questions of contractual construction. And of course, when I say curial law carve-out, that is essentially the bank's way of identifying it. That's not the way the court did it. And so we do say that one is not dealing here with kind of hard rules, but dealing with principles that inform contractual construction. And I would just highlight, we accept, of course, that Roman 6 says may. So both when you've got something that might engage the validation principle and something that might engage the curial law carve-out, that doesn't necessarily mean that the implied choice is different from the main contract law. It may do. But what that reflects is the fact that if you, for example, look at the validation principle, which derives principally from or one of the cases it derives from is the Sul America, the court expressly acknowledges you may have a situation where there is a greater or lesser risk that is presented that the main contract law would invalidate the arbitration. Or you may have a greater or lesser degree of interference with the parties' arbitration agreement. And of course, depending on the degree to which you have that interference and the degree of likelihood that may arise, that is going to inform an objective contractual construction as to whether or not the parties can have intended that result given the degree of the risk. And therefore, one can understand why the court has not said it will necessarily follow, because it's going to depend on an evaluation of that. And perhaps to a lesser extent, but still there's scope for it, under the curial law carve-out, you could have a situation where there is a degree of uncertainty, let's say, as to what the impact of the law might be. Conceivably, that is going to have some degree of impact on what the court infers objectively with the parties' expectations when they agreed that seat. Of course, what we submit and what the judge found was that French law is clear. No doubt about it. This is not some recent recherche development in French law. This has been the case, the experts said, for 30 years. So it's a very long-standing rule. So
when you go to A, any provision of the law of the seat, because we talk about the curial carve-out, but it's useful to look at the word. Any provision of the law of the seat which indicates that where an arbitration is subject to that law, the arbitration agreement will also be treated as governed by that country's law. It would be helpful to identify the provision of French law. Is it that provision of French law which says the international principles of arbitration apply?
yes.
It's that provision of French law.
And so it is the effect. It is the effect of choosing a French seat that causes the French courts to have the supervisory jurisdiction.
Yeah. But the provision of French law that we've just identified says that the international arbitration principles will determine effectiveness, existence, and validity.
Yes, as those principles have been developed by the French court,
Yeah.
and as is properly characterised as French law.
Yes,
See that.
it's properly characterised as part of French law, but why should a provision of French law that says the substance is going to be determined by substantive rules of international law, but we will treat those substantive rules as part of French law, why does that indicate that the arbitration agreement is to be treated as governed by French law? Do you see the way
I do, Malwa. I hope I'm going to meet rather than miss your
Okay.
point. Just if one takes a step back to the language of 6, what you'll see, there are two important words. One is provision, and one is indicates.
Assume it can cover case law. Don't worry about that for the moment. Yeah.
It was. Forgive me. What I was going to say about provision and indicates is this is not the language of requires or specifies. Provision is not the language of statute, or at least not the language of statute alone. There are many provisions of law. What this Roman 6 is driving at is essentially what can we take the parties to have understood and intended and expected as a result of their choice of French seat. And this is why I go back to the point that is important, that we're dealing with contractual construction here. And therefore, what is important is what the parties objectively can be taken to have understood was the effect of their agreement in circumstances where they never said the governing law of the arbitration agreement is English law. And when it's understood in that way, which we respectfully submit is the right way and the way the judge looked at it, it's the answer to your lordship's question presents itself, because what the if you ask the notional party when they say, well, do you know what the effect of agreeing this French seat is going to be? They would have said, well, yeah, of course, we know there is this 30-year rule that's applied by the French courts where they apply principles of international arbitration as developed by those French courts. Or at least, if they'd spoken for a moment to one of their lawyers, they would have understood that. And the court takes them as understanding that to be the case. So in that way, we don't say that this curial law carve-out is some peculiar policy rule that's been developed. It's an aspect of contractual construction. And I'm going to come back in a moment to ask, well, is there any real reason why one would sort of read down provision indicating so that it's only to be construed in the very narrow way that my learned friend would suggest, and we say no.
But how are those submissions about Henker 176A be reconciled with 5? And of course, if the contract said the parties have agreed to refer disputes to arbitration, and the arbitration agreement shall be governed by Ruritanian law, well, that's clear enough. But all this presupposes that there is no such clause. 5 says the choice of a different country as the seat of the arbitration is not without more sufficient to negate an inference. The choice of law governing the contract was intended to apply to the arbitration agreement.
My Lord, absolutely, these are totally consistent. So the situation in 5 is that all that you've got is somebody says, let's say, Belgian seat.
Yeah.
And it's not a part of Belgian law that, as a result of choosing a Belgian seat, Belgian law applies a mandatory rule that the governing law of the agreement is Belgian law. Okay. Now, what a party can't come and do is say, well, we chose a Belgian seat, and you, the court, should infer, in the absence of any kind of particular law, as a matter of Belgian law, you should infer that by choosing the seat, the parties must have intended that the arbitral agreement should be governed by Belgian law also. Now, this was the overlap argument, or the overlap argument is an aspect of it that was accepted in the Court of Appeal and then overturned by the Supreme Court. And much of the reasoning of the Supreme Court is devoted to explaining why that is not the powerful argument that the Court of Appeal considered it to be. But the important point is that what 5 is talking about is choice of seat without anything more attached to it, whereas what the curial law carve-out is talking about is a situation where, as a result of the law that applies, the law of the seat, that law is going to require the governing law of the arbitral agreement to be the law of that place. Now, that's exactly the situation that the judge held was applied in this case, and we say it is a straightforward application of the curial law carve-out.
How is French law different from probably every system of law which is interested in international arbitration, other than those where there is specific legislative provision, such as Scotland, Sweden and Brazil? Because French law says that the law of the arbitration agreement is to be governed in accordance with the intention of the parties. Well, English law says precisely the same. That's what paragraph 170 is all about. Probably Belgian law, and any other example you might care to mention, would have a rule to the same effect. So it seems to me that your French rule does swallow up the general rule.
My Lord, I would resist that, because I can have this checked in a moment. It's not my understanding. What I saw, there was this reference to the common intention of the parties. It's not my understanding that there is any operation of this French law that leads in any other direction other than applying international arbitration principles to it.
But everybody is trying to apply the intention of the parties. It's just that some systems think that you arrive at the intention of the parties by saying the rule is that the law of the main contract applies, and others think that you apply the intention of the parties by going for the law of the seat. And that's what it's all about, isn't it?
My lord, my understanding is that is not the way that the French rule is formulated, and that in fact what you have is a body of arbitration, international arbitration rules that will govern questions of validity, effectiveness, scope, and that those are simply applied whatever evidence there might be about party intention. But I will be.
Well, it may be that a French court would think that the intention of the parties is that the law of the seat should apply, but it's still not applying a rule that the law of the seat applies. It's applying a rule that you're looking for the intention of the parties, which is a bit different.
Well, looking for the intention of, I appreciate the distinction your lordship is making. I think I would be repeating myself if I said, as I understand it, that is not the way in which French law operates. So, for example, you can have whatever governing law of the agreement you like. If that comes before the French court, or it comes before a tribunal in France, they're bound to apply not that law, but the international arbitration principles, and that is what the judge found was common ground and was the reason why French law would apply.
The difficulty.
Forgive me.
I thought you'd finish a bit.
I had.
Paragraph 12 of the clause says paragraph 12 of the clause says all disputes arising out of or in connection with the bond shall be finally settled under the rules of arbitration of the International Chamber of Commerce. So we know that the parties want those rules to be applied to resolve disputes. And that'll be the same if it's French law or whether it's English law. If it's English law, it's because it's part of the contract. And I'm wondering whether the French law provisions that you talked about tell us anything about whether it was intended that the arbitration agreement be treated as governed by the country's laws. Is this just a mechanism under French law whereby they say, oh gosh, we've got to resolve it in accordance with the rules of arbitration. We shall deem those to be or incorporate them as French law.
That is not how it operates. It's an independently developed body of international arbitration principles that have been developed by the French court and are applied as the governing law of the arbitral agreement.
So there's a separate body of law which is formally part of French law, and that determines whether it is an agreement, whether it's valid, and who the parties are.
That is my understanding, and that's what the judge observed. And I'm rightly reminded that in Kabadji, when they describe the effect of what these rules are, they're described as rules of the French court's own creation.
Problem is, why wasn't Kabadji then? I thought Kabadji, it was English law, not French law. But well, if you're right, Kabadji's wrong. Sorry.
No, if I'm right, then there is an argument that was available in Kabadji, which is my argument, that was never considered by the court because it wasn't run. This is my Lord Justice Mail's non-barking.
And the authors of paragraph 170 didn't spot it.
Well, it wasn't
even though they set out 170 and they set out the content of French law.
Well,
I mean, that is the consequence.
It's not the consequence that they didn't spot it. We don't know, of course, what the thought process was. The only thing that we in this courtroom know is that the point was never argued, and if the point is not argued, it's hardly surprising that the point is not then dealt with. And I would feel somewhat rude.
Which point was never argued?
This is the Curial Law carve-out. So in Kabadji, there were issues about French law, which were considered in a completely different context from the question of the curial law carve-out. But the application of the curial law carve-out was never argued. So one party argued validation principle, but nobody ever raised the curial law carve-out. But
Kebabji must be wrongly decided, actually.
well, it's decided without the benefit of argument on this point.
No, it's wrong, because if you apply the law as exposited in Enker, 170 paragraph 6a applied, and the Supreme Court, Doc they pay, got it wrong.
Well, I would accept that. What I would feel bruised about,
Oh yes, sorry.
what I was going to say was a sort of anticipatory complaint, is that I would feel a little bit bruised if, having heard all of the argument on the principles about how the curial law carve-out operates, with the benefit of Sir Nigel Teare's decision and so on, if it was of frankly any weight that Kebabji was a case where a point could have been argued but wasn't. In my submission, that isn't something that could be of any moment to your lordship's consideration of this issue. And in fact, Kebabji didn't really involve much of a discussion about the validation principle either, because the validation principle that was argued in that case was regarded as misconceived. So you didn't even have any process of weighing up the general inference from the main contract law that you might make versus the contraindications in Enker Roman 6. And so that's why, for all sorts of reasons, Kebabji doesn't really help on this, because it's simply not a case that articulates the process of the court when it is faced with, on the one hand, a typical governing law of the main contract clause, and on the other hand, an argument that Enker Principle 6 is engaged. But I've slightly diverted from my path. What I also wanted to draw attention to, my lords, and this is our first respondent's notice point, is the closing words in Roman 6. And it says, either factor may be reinforced by circumstances indicating that the seat was deliberately chosen as a neutral forum. And so this wasn't something that the judge relied on, but we rely on it as a reinforcing factor that ought to, as it were, if it needed to, push this over the line as a case where the curial law carve-out was engaged. And what that refers back to is we see in the Karpatsky case. I'm just going to give the reference, paragraph 70 of Enker at page 559. There is a discussion of the Karpatsky case, and in that, one of the factors that the judge in that case relied on was what we call the curial law carve-out. The other factor that the judge in that case relied on was the neutrality of the forum and the inference that the parties may have wished that neutral forum to determine issues as to the validity and ambit of their choice. And so it seems that this requirement or reinforcing factor in Roman 6 that is referred to of neutrality, it doesn't spring from nothing. It's there for a reason, and it reflects the cases that were looked at by the court in arriving, in the first instance, at the curial law carve-out.
I'm a bit puzzled as to how this works, frankly, because every major international arbitration centre is a neutral forum, and that's why it's chosen. I mean, occasionally you get somebody who is from that country, but more often than not, you don't.
There there may be a difference between, there's neutrality in the sense that the parties want a forum that is going to deal with them fairly. There's neutrality in the sense that the parties are choosing essentially a third country that is not associated with one party or another. And it may be that, and that's perhaps a rarer neutrality than the first sense of neutrality. But whatever the case, the evidence that was before the judge is that France was chosen, informed by questions of neutrality.
How do you reconcile the admissibility of that evidence with the rule about pre-contractual negotiations?
I'm not sure that I can, my lord, so I will withdraw it. What I can say is that in the abstract, it's common ground that France is often chosen as a neutral venue. One of the attractions of France is as a neutral forum. So there's no dispute before your lordship that the concept of neutrality applies to the arbitration in France. And my lord, your lordship may think me simplistic, but what the task for the court is to apply ENCA, just to understand what it means.
Okay, you're right about that.
This is what I said about appearing simplistic. It may be that I am, but that's the ultimate task. So this is not a question of reinventing the wheel and having some complete first principles deconstruction of ENCA. So there's nothing ambiguous in Roman 6 about neutrality being a reinforcing factor. And we see that it has its antecedents in paragraph 70 of the court's reasoning in ENCA. And it's common ground that France was chosen for reasons of neutrality. Now, if those words are to mean anything, they have to be a reinforcing factor. And we say rightly so, because the parties may well, or are more likely to be taken, to have thought to themselves that questions of the ambit might be resolved by the court that they've chosen as their seat.
If we're, as it were, simply applying ENCA paragraph 170 as a quasi-statute, does the reference to being reinforced by a deliberately chosen neutral forum mean that this factor only comes in once we've reached, at any rate, a provisional conclusion that the exception is in play?
Your lordship mentions the statute of ENCA, and I'm disinclined.
Well, obviously that's not the right approach.
No, I'm disinclined to take that approach. It's not a point that I've thought about. I would be inclined to say that you look at 6 in the round and see where you come out. And I would be supported in that, I think, by the iterative approach to contractual construction that all of us live by. My lord, just to sort of round off this point about neutrality, part of the reason why I'm exercised about it is that my learned friend's answer to this in his skeleton is to assert that it means kind of the opposite of what it says. So he says that the only way in which neutrality has a role is that absence of neutrality might lessen the likelihood that the curial law carve-out would be engaged. As to which we say, well, that's not what it says. It says reinforce, and that ought to be given some meaning. And so we do say that the judge's application of ENCA, the judge's application of paragraphs 4 to 6 of ENCA were absolutely right. And if it's necessary to go so far, if we need it, he would have been reinforced by the neutrality of the forum. what I wanted to sort of progress to is the later stages of the anchor test, which is relevant to our second respondent's notice point. And so if we go then to Roman 7, we have where there's no express choice of law to govern the contract, a clause providing for arbitration in a particular place will not by itself justify an inference that the contract is intended to be governed by the law of that place.
What's the difference between 7 and 5?
7 is they're certainly covering similar ground.
I may. 5 is to be read as going through the gateway of 4. So Roman 4 gate, the premise is you have a choice of law in the main contract, and then 4, 5 and 6 apply. Whereas 7 and onwards is where you have no choice of law in the main contract, as I understand it.
Well, at any rate, what I was going to focus your lordships on is 8. So in the absence of any choice of law to govern the arbitration agreement is governed by the law with which it is most closely connected. And where the parties have chosen a seat of arbitration, this will generally be the law of the seat. And this, so essentially, my lords, this principle is now addressing absence of choice of law to govern the arbitration agreement.
Are we ever going to get there in this case? In Enker, there was no choice of the governing law of the main contract.
No.
But the conclusion was it was most closely connected with Russia and therefore
Yes.
Russian law.
And
that's the way the court decided the case in the end.
Yes.
But in this case, aren't we either within 4, or in which case the exception doesn't apply, but there is a choice of English law, or we're within 6, in which case the exception does apply and there is a choice of French law. It's got to be one or the other, isn't it?
My lord, your lordship will appreciate that essentially that's my primary submission. My primary submission is if you find the Curia law carve out, then there are 2 expressions that are used.
Well, if you're right, you win. But if you're on this proper law,
oh,
but if you're
forgive
wrong,
me, my lord.
then the general rule applies. So we don't get to 8.
Forgive me, my lord. I was too quick in agreeing with you, which is always a temptation. I'm going to expand on this, but okay. Essentially, when you approach following through the Enker principles, there are always 3 options. One option is I'm going to go with I can conclude that the objectively construed, the parties intended that the main contract law was the governing law of the arbitral agreement. Fine. Option 2, I can conclude that because of the effect of choosing the French seat, that on the contrary, the parties intended that they were going to apply French law as the governing law of the arbitration agreement. Option 3, which is what 8 contemplates in part, is that the court is presented with countervailing indicia and factors. And the court is, in fact, not able to reach a clear conclusion in one direction or another as to what the parties must have intended. Now, this is an unusual situation because usually, of course, when the court is presented with a contest of contractual construction, it is binary. You have to decide what it means because otherwise you can't decide the case. But what we have when we're looking at these kinds of clauses is the benefit of a default rule. So the default rule is the rule that applies in the absence of agreement. And that default rule is not a rule that has got anything to do with the intention of the parties. It is just a policy rule. It is a rule of law that if you haven't got a choice of arbitration agreement, you can't determine it, then it is the place of closest connection, which will almost invariably be the seat.
No, I don't think that is it. When you get to 4, and to 5, the choice, no, 4, where the law applicable to the arbitration agreement is not specified, a choice of governing law for the contract will generally apply
Yes.
to an arbitration agreement, and that's an inference.
Yes.
Not a rule of law, it's an inference from what the parties have agreed. The fact that they've got a contract, and the fact that one part of it is an arbitration agreement, and the fact they've got a clause saying the contract is governed by English law, leads to the inference that all parts, including the arbitration agreement. And 5 and 6 are quite clearly looking for factors which negate such an inference.
Yes.
And the inference is that it's the choice of law governing the contract that applies to the arbitration agreement. So you're looking for something, in inverted commas, sufficiently strong to negate the inference, and then you're looking to see whether there's any provision of the law which indicates that rather than it being the inference that it's the choice of law in the contract as a whole, that there's something in the laws governing the seat which indicates that in fact they were switching from the English law to, in this case, to the French law. That's how it works, isn't it?
Well, I would respectfully resist that, because simply because of if you look at the way Roman 6 is articulated, the opening words say additional factors which may, however, negate such an inference. So there you've got
the inference that you're negating.
The inference that the main contract law will be the governing law.
Will apply to the contract, yes.
May, however, negate such an inference, and may, in some cases, imply that the arbitration agreement was intended to be governed by the law of the seat. So, in principle, at least, now you may have a situation where the inference is negated, but because of the countervailing factors, you may no longer have your inference that the main contract law is the governing law because of the countervailing factors. But you may not be able to go the further positive step and say, I can positively conclude that what the parties intended was that the governing law should be the law of the sea. Now, in that situation, where you end up is because of the countervailing factors, you can't conclude one way or the other.
But if you can't have factors that imply that it's not the law in the agreement as a whole, then you're stuck with the agreement as a whole. It's not I've negated the inference, it's no longer the law of the main contract, but I can't go far enough to show that it's French law, and therefore there's some other provision. Clearly it's meant to be, surely, that you start off, is there expressive provision for the arbitration agreement? No. Is there express agreement for the contract as a whole? Yes. Inferences it applies to the arbitration agreement. And then you're looking for things which say, no, it's not that system of law, some other system of law. And it's not saying you can negate the inference, but not go so far as to say it's the French law. And then you're into a kind of desert to default desert. It's all part of which law applies. And the answer is it's the one they put in the contract, unless you can show it's another one.
My lord, I would resist that. I'm going to find a different reason for resisting that is that if you look at the validation principle, where that comes from, the main case that the lordships in ENCA rely on, the majority, is still America. That's the main case that they refer to, and it's Lord Justice Morbick's formulation of when the validation principle should arise that they adopt in that case. Now, if you look at what happened in Still America is a case where there was a main contract law, which was English law. Was it? Forgive me, Brazilian. Forgive my offence. Right. There was a main contract law, which was Brazilian, and there was an English seat of the arbitration. Now, when the court came to consider questions of implied choice because the arbitration agreement governing law hadn't been specified. The court did not say, well, the starting presumption is main contract law, and the facts to do with the validation principle are not strong enough, and therefore I'm going to treat this as implied choice for main contract law. That is not what the court did. What the court actually did was to say that because there were these countervailing factors that were engaged by the validation principle, it was not possible to say that there had been an implied choice. And therefore, the Lord Justice Morbick expressly went on to determine the matter not as a question of implied choice, but as a question of applying the rule of policy of closest connection. Now, that is, if one goes to page 225 of the bundle, I realise that this has been an authority-free submission so far. If you go to page 225, and if I could ask you to read perhaps from letter B down to letter F, that's the bit of Sil America which makes this point. And just to complete it, if one goes to page 574 of the bundle, just to look at Enker, forgive me, 570, paragraph 109, you see their lordships are adopting the formulation there in Lord Justice Morbick in Sil America. And then paragraphs 103 of page 568, that is describing the facts of Sil America. So there's no doubt, and there's no doubt that when they came to formulate the validation principle as it's in Roman 6, that it was Sil America that they had in mind.
I can see that, and it may support Mr. Houseman's submission that in fact A and B should be separate paragraphs, because I can see how the validation may mean you'd say, crikey, they can't have meant what they said, because if they meant what they said, the whole clause is ineffective. And that might leave a question mark as, well, what do you do next? But in little a, I did read little a, but I got your submissions, don't worry, that you negate the inference that the clause saying the contract as a whole is English and French law applies also to the agreement, because you can see from the provisions of the law of the seat that it was meant to be the law of the seat, that it's not the one, it's switched to the other. But I've got your point that no, you might use the law of the seat to say, no, they can't have, the inference has been negated, and therefore you're back to closest connection. I have the point.
Yes, and really, I'm trying in my submission to be true to the principle that we're engaged in contractual construction. And it must be the case that when you are engaged in contractual construction, you can essentially reach a position where you can't reach a clear conclusion because there are countervailing factors. and the law provides an answer in those circumstances, its closest connection. It's not my primary case, because my primary case is that it's clear, because French law is so clear.
But it, surely, doing my best to read ENCA paragraph 170, it does seem to me that subparagraph 8 is dealing with cases where there is no express choice of governing law, because otherwise 8 is flatly contradictory to 4. It really would be it's not the exceptions following up the rule, it would be a completely different rule. That if you find it all very difficult, so the presumption must be that it's the law of the seat. But how is that to be reconciled with 4?
My Lord, I can't do better than Lord Justice Morbick. That was exactly the situation that he found himself in. He couldn't, he competing considerations, couldn't reach a conclusion, so its closest connection. And that is, you know, supported by the majority. I should say Lord Sales had some reservations as to whether or not it was really a closest connection case, but the majority simply applied and approved Sul America. And I would say, my Lord, that you'll note that in Roman 8 it says any choice of law, in the absence of any choice of law to govern the arbitration agreement. So it's talking about the arbitration agreement. It's not saying in the absence of any main contract law. So it's not expressed to apply only to the ENCA situation where there was no governing law of the main contract. Rather, in my submission, it is expressed to apply to any situation where you can't conclude that there's a choice of law to govern the arbitration agreement for whatever reason.
What about the closing words of subparagraph 9? I mean, both 7 and 9 seem to be dealing with cases where there's no express choice of governing law. You say 8 is more general. It does seem odd.
9 I read simply as saying in multi-tier arbitration clauses that the fact that you've got the multi-tier aspect isn't going to affect things one way or the other. My Lords, can I'm conscious that I need to engage with some of the other arguments so some of these I've effectively dealt with already, but at least if one took it from the written arguments, the main points that seem to be made on the gateway issue are first of all a submission that when you read ENCA, it's clear that the main contract law is not likely to be displaced, or similar cognate expressions that it's going to be very, very difficult to do so. Secondly, there's reliance on the bond terms. Thirdly, there's the statute restriction. Fourthly, there's the direct link restriction. Fifthly, there's the domestic contract law. And I'll hope to say something about Renvoi in that context. And as it was expressed in the written arguments, there was quite a lot about the thrust of ENCA, the critical cadence of ENCA, and so on. All that I would urge your lordships is to observe that when one comes to look at the ENCA principles, which are clearly intended as a guidance that judges can apply, what one does not find in the words of Roman 6 is some expression that says that it's going to be very, very difficult to dislodge the main contract inference, even where you can show that you've brought yourself within either A or B. There's no indication of that whatsoever. And of course, we accept it's going to be a rare case, where you actually have a provision of the foreign law that means that you are in the territory of the curial law carve-out. But in these rare cases, Sweden, Scotland, France, then there's no reason to suppose from the way in which it's expressed that it should be rare. And that remains the case.
France is not a rare case. I mean, arbitration in France is very, very, very common.
Well, my lord, rare in the sense of global litigation. I'm not. There is clearly it's an exceptional situation. Really, all I'm pointing out is that if you tot up the number of jurisdictions where this situation, foreign jurisdictions where this situation may arise, they are exceedingly few in number.
But do we know that? Do we know what Belgium does, for example? Which is also a French-speaking country, very influenced by French law.
All I can say is that the researchers of those behind me and those opposite me, or rather to my left, have only turned up those examples. I cannot say to you that is. I cannot categorically
I don't think
say
we have the
that's
information to know that it's little.
Those are the only ones that we're aware of. Now, that sort of situation it tends to be supported when one actually looks to see the underlying cases that were relied upon, in formulating the curial law carve-out, because those provisions do not say. For example, if one goes to paragraph 70, looking at the Karpatsky case, when those cases are reasoned, the courts don't say, well, Swedish law provides, has this provision, and now we must undertake some difficult weighing exercise to see, this is page 559, now we must undertake some difficult weighing exercise as part of Roman 6 in order to try to ascertain whether it is really the case that the curial law carve-out displaces the main contract law. On the contrary, if one looks at the top 560, it's very simply stated at the bottom of paragraph 70. It follows that by providing for a Swedish seat, the parties were impliedly agreeing that Swedish law should govern. And then in relation to Scotland, paragraph 71, a similar inference could also be drawn. That's in relation to Scotland. So what one does not find on a fair reading of either the Enker principles in 170 or the reasoning that went into it is the idea that once the curial law carve-out, once the circumstances to bring you within paragraph A are there, that there is some further high hurdle that you have to overcome. I'm not going to spend time on the emphasis that the bank placed on the dissenting judgments in Enker, which were relied on in the written arguments to say that those dissenting judgments supported. They were dissenting judgments, they were not applying the same test as the majority. And ultimately, my lords, what we say is that you are approaching this as a matter of contractual construction, but you are being guided by the principles in the specific example here, and you should take paragraph 176 at face value. If it is, obviously all bets are off if the governing law of the arbitral agreement has been specified. That's it. That's the end of it. We're only dealing with a situation where the agreement has not specified the arbitral agreement. Now, in those circumstances, there's no reason to have any degree of scepticism or reluctance or inertia if, in fact, the obvious impact of the parties choosing the seat would be that a foreign law would govern the arbitral agreement. One should, in fact, grasp that, as the judge did, and say that the parties, objectively speaking, they knew, they must be taken to have known about the law. They certainly knew that they were identifying the seat. They must be taken to know what the effect of that was. They must be taken to know the principles of French law were going to apply. My lords, just in relation to the bond terms, what is, as we understand it said about that, is that there are various aspects of that, of the clauses, which may take it beyond the standard provision. This agreement is governed by English law. Now, what we say essentially is that whichever way you look at it, this is just the standard provision. There isn't anything to take one further than the standard agreement towards specifying the governing law of the arbitral agreement. And we also say that it's not that profitable to pore over it, as my learned friend was doing, because once you're in that situation where you've got an agreement to the effect this agreement is governed by English law, then you are in the territory of looking at implied choice. But what we would say, if necessary, in particular if necessary to distinguish from some other cases, is that if you are going to dig into what these particular terms indicate, there are at least some indications in the bond terms that give one pause about whether or not this was intended to refer to the arbitral agreement. Not least the fact that the bond, being an undefined term, has a fixed duration, which is plainly not the duration of the arbitral agreement. And so what one has are, frankly, indications going both ways. On the one hand, you have, it's plainly the case that the letter agreement, the letter in which it's contained, includes clause 12. On the other hand, you have a reference to bonds that is undefined and that does not make sense if it is understood as embracing the arbitral agreement in terms. And where you end up when you look at those competing factors is essentially back at square one. You've got an implied choice case. Yes, you've got an inference, a general inference that the main contract law is the same as the arbitral agreement law, but it's all about the curial law carve-out. My lord, so that's the bond terms. If I could just then address you on statute. Now, the way in which it was put in writing was to say, well, the two examples that were given in Enka, the Karpatsky case and the Scottish Act, those are both statutes, and therefore that was all that the court in Enka can have had in mind when they expressed lim A of Principle 6. And we say no as a matter of textual analysis, but perhaps more importantly, no as a matter of principle. Because as a matter of textual analysis, there is nothing in 176 that says statute. Given that they were looking at statutory provisions, it would have been the easiest thing in the world to do so. The fact that they didn't and referred to provision tends to suggest that they had a broader test in mind. That test, that is also rather emphasised by the fact that elsewhere in the reasoning, one finds plenty of references to the same system of law or that country's law, something like that. They were not limiting themselves to some particular aspect of a country's law, but we're talking about law in general. But as a matter of principle, my lords, we do say, why would it matter whether a particular provision was found in a statute or in the customary or case-developed law of a country? Because all of this is being looked at through the prism of contractual construction. And the only thing that matters for those purposes is what the parties' intentions and expectations were, or are be taken, or should be taken as being, at the time of contracting. And we respectfully submit that the only thing that matters there is how clear is it that that would be the effect. And we say it's clear, so clear that it was common ground. The judge thought so. And if, therefore, you ask yourself the question, what should we take the parties as having expected or intended as a result of their choice of French seat? Well, this provides the answer. And it ought, therefore, it shouldn't matter at all whether it's in a statute or some other provision. I mean, what if you had a statute that was unclear? It shouldn't make any difference whether the clarity is contained within the statute or the clarity is contained elsewhere. All that matters is the clarity. And as my Lord Justice Males said, it would be rather odd for this court, which develops its authority in the way that we do, to adopt a rule that said, absolutely not, we're going to ignore any body of foreign law, whatever it may say and however clear it may be, unless it is contained within a statute. We respectfully submit that does not make sense. The next point that was identified was this concept that there has to be a direct link. And this was, I think, said also to be something to do with constructive, constructive linkage. So this seems to draw a distinction between the application of the foreign law being the effect of choosing a seat in that jurisdiction, and the foreign law expressly stating that where the seat is within that jurisdiction, the foreign law shall govern the arbitral agreement. And three brief points, if I may. There's no such requirement in Principle 6, which is simply expressed as cause and effect. There's no. It's really the same point as the point about statute. That why would one draw such a distinction? If one is only concerned with identifying intention objectively, why would you draw a distinction between it following from the seat versus it just being versus a stipulation of the seat? In practice, of course, there is direct linkage between choice of a French seat and application of French law to the arbitral agreement. The application of the French law only arises because the arbitral process is governed by French law. That only arises because of the party's choice of a French seat. So I suppose theoretically you might have a situation where the seat was not France, but French law nonetheless governed the arbitral process. But that would be a very odd. Agreement to reach. And so in practice, there is a direct link, and certainly as direct as matters for the purposes of determining intention. Then, well, the point that Milan Fenn made at some length was the need to be looking at matters of domestic substantive contract law, rather than the principles of international arbitration that are identified here. Again, if one looks, for example, at Principle 6 itself, that refers to that country's law. ENCOAT paragraph 69 refers to system of law. these are all expressions that are in the widest possible language to refer to the law of another country. And again, another example, paragraph 94, page 566, choosing the law of that place. What you don't get from this is any hint that for these purposes, what one is looking for is to subdivide the law of the foreign country and only identify some subset. There is no mention of like for like or equivalence. And in principle, there's no reason why there should be. Because again, all that one is doing is looking at questions of inferred intention of the parties. And I would add, my lords, that we accept and agree that a part of what was animating the decision in Enker was a desire for a position that was certain, so that judges, litigants could see quite clearly how they ought to apply it. It is hardly a recipe for certainty if, in any case, it will not be sufficient for the experts clearly to identify what the effect of the foreign law is in terms of the governing law of the arbitral agreement. But in fact, to go further, and for the experts also to agree which subset or classification of the foreign law this particular provision or rule belongs in. Because that is really an argument for the lawyers only, for the foreign lawyers, and it is apt to create a great deal, in my submission, of uncertainty as to how this will be applied, vis-a-vis a bright line rule where you can simply identify the law and that is it. In this context, one of the points most strongly made by my learned friend is Renvoi. So he says, well, that Enker allows a limited renvoi, but I am going too far and extending it beyond those proper constraints. And so Renvoi, he's wrong about that. The Enker does not involve renvoi properly understood, and neither does, and certainly not on the way in which we understand the Curial law carve-out to operate. So renvoi arises where, in determining choice of law, one looks to the foreign legal system. That foreign legal system, in turn, refers to another legal system or back to the original country. And if I can just give your lordships a reference to the Dalla case, Authorities 5, page 843, sorry, page 164, paragraph 124, but I won't go to it given the time. And so we agree the English conflicts principles are applied without renvoi because it can lead to a circular chain of reasoning between the English court and the foreign court, or applying the law of some third court. And either way, the result is confusion. We need to avoid that. So the important point there then is that the Curial law carve-out is not renvoi. It simply asks whether the law of the seat would apply the law of that country to the arbitration agreement. And if so, then that's a strong indicator as to the party's implied choice of law. So there's no room for the law of some third country to apply. There's no room for the foreign court to refer it back to the English court and have a circular discussion that way. And so Enker is not renvoi. It's just applying the law applied by the law of the seat. And so we don't agree that the principles of renvoi are engaged here or are offended if one goes beyond looking at domestic substantive contract law. My lords, there are a number of other points that are made, most of which I've already covered, that are points of principle about which are relied on as supporting this narrow reading of Anchor 6. Could I just briefly address you on three of them, because I think I've dealt with the others. One is the need for legal certainty. One is avoiding evidential disputes, and one is creating too many exceptions. And these are all, to some extent, they've been made by my learned friend orally, but they all come from Bundle A33, paragraph 39 of my learned friend's skeleton, and they correspond to letters B, subparagraphs B, C, and D of that. There's not a great deal to say about certainty, because I'm not submitting to your lordships that the curial law carve-out is in some way engaged when, let's say, there's an argument that the foreign law might apply in one way or another, or even where there's a sort of genuine ambiguity about whether it would apply. That's not the territory of the curial law carve-out. There is nothing. There is no uncertainty in saying where the foreign law is clear, then the courts will be able to apply the curial law carve-out. And there's no distinction to be drawn between the clarity of a statute and the clarity of a law. And this goes to what my learned friend said with, in my submission, quite a lot of exaggeration, was that this court is going to be flooded with jurisdictional disputes raising this point, and it's going to be days rather than hours to argue about all these disputed questions of expert evidence that are going to come before the court. Not so. It's worth considering what happened in this case. There was evidence, expert evidence of French law. That expert evidence was then agreed between the parties. The judge was presented with an agreed position, as stated in my learned friend's skeleton before him. And all he needed to do was to rehearse that in his judgment in order to deal with the situation. And that is what is likely to happen in these sorts of cases. Because bearing in mind that one is dealing with questions of contractual construction and intention, if you can't show that it was clear what the effect would be of the choice of seat, of the foreign seat, then you're not going to be able to support the submission that the parties should be taken to have intended it. And so the only situation where this sort of curial law carve-out is going to arise in practice is where the position under foreign law is well established, is well known, and so the sort of floodgates argument that suddenly you're going to have all these disputes, it's simply not going to arise, because the minute you've got two experts arguing, one saying yes it would apply this law, the other saying no that's completely wrong, well, how are you going to arrive at the view that the parties must have understood the situation to be obvious at the time of contracting? So that really is what I wanted to say about avoiding evidentiary disputes. And then the last point, I've really, I suppose, been over this, that it would produce a situation where it would produce too many situations where there was a different main contract and arbitration agreement law, and this is 39D of their skeleton. It's really not at all clear what the basis for this submission is. I mean, how many is too many? My Lord Justice Mayles rightly says that there are a number of cases that may involve the French jurisdiction. But on any view, what we're talking about here through the application of the curial law carve-out is an exception to the more general situation where the main contract law is going to apply as the governing law of the arbitral agreement. And so it is really not the case that what one is talking about here is some upending of the cadence or the principles in ENCA at all. What all that the judge was doing was simply applying them. My lords, I said something about Kebabji at the earlier stage of my submissions. And so what I was going to do, but I would invite your lordships to look at paragraphs 88 and 89 of that, which we looked at on the question of French law. And I would also invite your lordships to keep in mind the submission that I've already made, that Kebabji is simply not going to help in the weighing, how one weighs in the balance the general inference from main contract law and Principle 6, because the Curial law carve-out was not argued and the validity principle wasn't engaged because the argument was misconceived. My lord, going on to the position on proper forum. My lords, at the outset of my learned friend's submissions to you this morning, he made some quite emphatic submissions about what he says RCA will do in Russia, if not restrained. There isn't evidence before you about what steps may be taken. This is, we suggest, speculation. The evidence goes no further than the expert evidence from the Russian law experts about what jurisdiction may be available.
But you started proceedings in Russia unless you're stopped. Isn't the inference you'll carry on? Why would you carry on?
Well, the proceedings were started prior to the anti-suit injunction.
Yes, I know. But say they don't get one, you will carry on.
I can't say before you whether they will or not. But what I want to caution against is proceeding on the basis of a submission about, it was put as high as what will happen, what they're bound to do, without there being a proper evidential basis for it. Now, the position before the judge was that when one was talking about substantial injustice, what one's really talking about is England. What can happen in France? What can happen in England? And we say that was the right way to consider it. There is no anti-arbitration injunction in Russia sought by RCA. There are also, as you're aware, these arbitrations that have been brought by Commerzbank and Deutsche Bank. RCA has not sought any anti-arbitration relief in Russia in respect of them. Again,
there are injunctions.
There are ASIs. Yes, there are presently. As to the other point was made was that there is a difference in the asset position between UniCredit and Commerzbank and Deutsche Bank. And again, it's difficult to respond to these sorts of submissions because there's no evidence of what their position assets-wise may be in terms of executable assets. We simply don't know, nor do we know what the extent is of the UniCredit assets in Russia. So,
what do you say about the Russian statute, which we were showing? Article 458 of something. 258, I believe. 258.
Well, we don't dispute the effect of the articles that they allow for essentially the arbitral proceedings in Russia to be considered unenforceable. That isn't the scope of the dispute. What we do say, my lords, is that when the approach that the judge took, which was different from the approach that was taken in the Deutsche Bank Court of Appeal case, which I'll come on and show you, is that the judge rightly considered what course of action, what relief is available in France in the arbitration. And that was the right question to ask, because if it is the case that you can get substantial justice in France through the arbitration, then this court has no basis for reaching the conclusion that this is the proper place for any claim, because it's perfectly clear that France is the natural forum. Parties have chosen a seat in France, and it's the securial jurisdiction. It's perfectly clear that arbitration in France is available. It's just that the bank doesn't want to. And so what matters is, could an award that delivers substantial justice be obtained in France? But I'm slightly getting ahead of myself, so I will. I'll come back to that. So, my lords, you've been shown the Court of Appeal case in the Deutsche Bank. If I could just preface, I'm going to show your lordships that, but as you know, that was an ex parte appeal from an ex parte first instance hearing. Our RCA was not present and made no submissions at it. One of the points that was made, at least in writing, was that this court should treat the Deutsche Bank Court of Appeal case as authoritative and persuasive today. We resist that. Your lordships should obviously look at it.
Depends what you mean by authoritative. I think it's probably pretty well developed doctrine. It's not binding. In the Young and Bristol aeroplane case, it's said to be persuasive, but you say it's not even persuasive.
I say not, because if effectively the position is that there was the ex parte hearing which was then appealed. So there was then an inter partes hearing before Mr. Justice Baker in the Deutsche Bank case. That was resolved by consent because it was dealt with by consent, subject to the outcome of this appeal. So in reality, the arguments that were being made in the Deutsche Bank Court of Appeal case are really only being dealt with the benefit of submissions from the parties for the first time, in this court at least, today. And so there hasn't been an inter partes hearing in relation to that previously. Now, ordinarily, if you obtained an ex parte injunction and then you had the return date, it's entirely afresh. You would be presenting all of the arguments anew. You wouldn't be able to say to the judge, well, you should regard the ex parte ruling as persuasive unless some very strong reason is shown to the contrary, because it would all be afresh. It would be the return date. And that functionally is where we are today, because of the fact that no representations were made by RCA in the Court of Appeal case. But of course, that is not to say that one shouldn't look at it. We should look at it because it's part of my submission that the outcome in the Deutsche Bank Court of Appeal case went wrong.
Do you know whether Deutsche Bank anticipated and drew to the attention of the court your argument that this was a case for the exception in paragraph 170(6) to apply?
I don't know.
There's no reference to that judgment, and it may be that Deutsche Bank didn't appreciate that that's a point that RCA might run. Well, I don't know.
I don't know, but I have been working on the basis that if such an argument had been made, the court would have been bound to consider it and would have referred to it in the judgment. And of course, perhaps not in the one pager that was before Mr. Justice Teare saw, but in the fuller arguments, you would expect there to be some reference to arguments if they had been made. And in fact, what you see is a very, very short statement that they're satisfied that the gateway had been met. So that is obviously one of the points that we would have made had we been there.
So it can't be said, you would say, therefore, that the Court of Appeal was in any way expressing any view about that argument, because it wasn't apparently aware of it.
And I'm told from behind that it was not argued.
Yeah. Okay, thank you.
So look, if we could then briefly go to Authorities 20, which is the Court of Appeal decision. My other friend showed this to you. The material bits of it are paragraphs 34 to 41, which starts on page 772. And since my own friend's been through these, I won't take your lordships through it in detail again. But what you'll see there is that the way in which the case is characterised is consistently as a claim for an ASI. And that is where we would probably suggest that the court went wrong in its characterisation. Three points to make about the decision. No consideration at all of what relief other than an ASI from the French court would in principle be obtainable by Deutsche Bank in France. Secondly, no reference to any of the established authorities about characterisation of the case, the Hawaii case, for example. And third, as I've said, it's consistently couched in terms of a claim for an ASI rather than a claim for breach of the implied promise not to arbitrate, for which relief of an ASI is sought.
Is that right? Because paragraph 35 does say a good arguable case that the claim falls within the gateway, namely a claim in respect of a contract governed by English law. And I know Mr. Houseman doesn't like the way I put it, but this is a claim for breach of clause 12 of the bond, an injunction to restrain any further breaches.
Your Lordship is quite right. In fact, it was the next point that I was going to come to. But if you look at it, it starts okay, because if you look at paragraph 35, when they're considering the gateway and whether the claim falls within the gateway, it's expressed in a way that one couldn't disagree with. The difficulty is that as the analysis relevant to forum rather than gateway goes on, what you find is that there's a consistent reference to this being a claim for an ASI. And that, and of course, the fact that they were only thinking of it in these terms may be a function of the fact that no arguments were being put forward about the different kinds of relief that might be available in France, maybe not in the French court, but through French arbitration. And so when one defines the case or the claim in a way that is peculiar to the specific relief that is being sought from the English court, then it becomes self-fulfilling, because if that particular relief is unavailable, then that claim cannot be brought, only some other claim.
Well, what about paragraph 38, actually, which doesn't just do it by way of anti-suit? It analyses it as a promise not to litigate rather than arbitrate. And when you're seeking a remedy for a breach of that promise, because it's a breach of clause 12 here, then they will readily enforce that promise. He knew that he was enforcing the promise.
There is certainly a reference to a promise there. I don't say that the court completely ignored the underlying cause of action. What I do say, and I should emphasise, this is not a criticism of the court. This is just a function of the material that was presented.
He says, as it developed, it was only a claim for ASI, and I just looked at paragraph 38, and it didn't seem to develop in that way.
But your Lordship's right to ask me about it. I mean, if you look at, for example, paragraph 40, the only claim in the present case is a claim for interim injunctive relief. if you look at the beginning of paragraph 41, in those circumstances, it seems to be the forum in which the claim for an interim ASI can be suitably tried for the interests of all the parties and for the ends of justice, the English court, on the simple basis that such a claim cannot be given effect to France. And so that's referring back to the claim for the ASI.
I think you've got to read 39 before you get to 40 and 41. You've got to read it as a whole. He says, hence, because there's a breach of promise, he will usually grant an anti-suit injunction, no more than a particular application of the general principle that an injunction could be granted to restrain breaches of a negative contract. And 4041 is really just shorthand for that, actually. Isn't it?
My lord, that's not how I read it. I read it as only identifying it as a claim for an ASI, and that's why when one gets to paragraph 41, it says the real choice is not between two competing forums. This is around just below G, but between the English court entertaining the claim and the claim not being brought at all. So one has to ask the question: is it really the case that there is no claim that could be brought in France to enforce or vindicate the rights of the bank? And there are two aspects to that, because we say that there clearly are two ways in which the bank can act. First of all, you have through the arbitration, the ICC rules clearly provide that an anti-suit injunction can be obtained from either an emergency arbitrator or from the tribunal once constituted. I know that your lordships will be well familiar with those rules, so I'll just give you some references if I may. Page 904 is Article 28. Page 905 is Article 29, which enables the appointment of an emergency arbitrator for matters that cannot await the constitution of the tribunal. Page 939 sets out Appendix 5, which contains the rules for the appointment and the powers of the emergency arbitrator. And I draw attention to page 941, Article 2.1 of Appendix 5, which makes the point that the President usually appoints an emergency arbitrator within 2 days. And then the pages 943 and 944 cover the ability of the emergency arbitrator to make an order and when it will continue in effect. And what this comes to is that the bank could have commenced arbitration in France. It could have appointed an emergency arbitrator within 2, maybe 3 days. It could have sought to secure an anti-suit injunction from the emergency arbitrator. It could have issued a request for arbitration. It could have, in a matter of weeks after that, led to the constitution of the tribunal once you've had your
request. It doesn't want to arbitrate, it's not the one that wants to arbitrate. It wants to make you arbitrate. You're the one that wants to enforce the contract. And they're saying if you're doing that, you should go through arbitration. So it's rather odd to say, you start arbitration because we want to sue. You get an injunction stopping us not arbitrating. And then you carry on and we'll have the argument in the arbitration that you started. It seems to me, not being involved in this area, Alice in Wonderland.
Well, my lord, it's the bank that has to make the case that this is the proper forum. Now, in order,
if you're right, the bank could have done all those things, but if it had, it is your case that anything that an arbitrator or emergency arbitrator ordered would not be recognised or enforced in Russia, and if it had done that without the protection of an order of the English court, there would be nothing to prevent you from getting an anti-arbitration injunction in Russia to bring the whole thing crashing down. Now that's Mr. Houseman's case. Is any of that wrong?
Well, two points, if I may, my lord. The first point, perhaps 3 points. What your lordship is considering is the difference between an ASI from the French arbitral tribunal and the ASI from the English court, backed by a contempt regime, such that one can say that you cannot get substantial justice if you get the ASI from France. So in order to make that case, what my learned friend needs to say is that we will not abide, or we would not abide by an anti-suit injunction if it came from a tribunal in France. And that therefore, so his first stage of the argument would be to say that the availability of contempt, because that's the only different aspect that he seeks, the availability of a contempt jurisdiction is essential to the obtaining of substantial justice, which must be based on the idea that we would not abide by an order of the tribunal. Second,
you said you wouldn't. You said it's all unenforceable.
Well, my lord, the statement of claim in the Russian proceedings was prior to the interim anti-suit injunctions.
But you're not offering any undertaking to comply with an order of an arbitrator, are you?
I'm not in a position to do that as I stand here today. But ultimately, my lord, it's not just it's their burden, and they're the ones who have to show that there is substantial injustice or a serious risk of it if they do not have this contempt jurisdiction attached to it. But as a matter of principle, they also have to show that the availability of procedural safeguards through enforcement, contempt jurisdiction, is the sort of thing that these courts will take into account when reaching views about serious risk of substantial injustice. And we have, your lordships have seen from what we have put in writing, all of they're obviously well established that when one's looking at differences in the measure of damages, differences in the kind of relief, the Dampierre and de Dampierre, and the cases that follow it, those are not the sort of things that the court is going to get engaged in order to take a view about substantial justice. And the same must apply when one is not actually talking about the judgment that you would get, or the award that you would get, but the procedural mechanisms that are available to a person in different courts as to contempt and so on. To put it shortly, I mean, different jurisdictions have different approaches to the contempt jurisdiction. Our jurisdiction is particularly robust, but that is not a reason to undertake a sort of comparative law exercise as to and form a judgment about the adequacy of the foreign legal system based on that. And so that is why I do put it in terms of they are perfectly able, the bank is perfectly able to commence arbitral proceedings in France if it so wishes. It does not suggest that it would in some way be at risk of not succeeding in France. Its comments are limited to the position in Russia. And they would, the result of that would be that they could have obtained an interim ASI from the French court, from the French tribunal. And so that goes both to questions of availability. It's not an answer to availability to say, I don't want to. But it also goes to questions about serious injustice or serious risk of substantial injustice. My Lords, I do want to address you briefly, if I may, on the question of characterization and how you should go about that, just to show you.
We're really running out of time. I mean, like how much further have you got to go?
My Lords, I could conclude within 5 minutes.
Right, good.
My Lord,
Go on.
forgive me, because I was rather expecting that my learned friend would sit down at some point before 1 and allow me more time, but I do apologise.
Mr. Houseman ran over, as I recall, by 5 minutes. It's quite conventional for appellants to take a little longer than respondents in opening. Carry on for another 5 minutes.
I'm grateful for the indulgence.
Yes, of course.
My Lord, could we just go to authorities, tab 17, please? This is the recent Harrington case. Forgive me, I've given you a bad reference. Could we go to the Hawaii case? This is the one in the Court of Appeal, and go to page 381. Looking at paragraph 33, I just wanted to remind your Lordships of the Harrods Authority and the importance of characterisation. And your Lordships will no doubt look at this again. But essentially, in that case, what happened was that Mr. Justice Harman, when faced with a contest between Argentina and England for an unfair prejudice petition seeking a buyout of shares, characterised the case as a claim for an unfair prejudice petition pursuant to English law principles for a buyout. And when this came to the Court of Appeal said, well, the difficulty is that if you identify your claim, if you characterise your claim by reference to the specific relief that is being claimed in England, then it's not surprising, as Mr. Justice Harman concluded, that it's blindingly obvious that it all points to England. That is the function of selecting your premise by reference to specific relief claimed in England. And so that warning is an appropriate warning in this case, because one has to be a bit careful about framing the claim or the dispute as being a claim for an anti-suit injunction backed by contempt, which will produce the outcome. Well, the only place you can do that is England, and therefore it must be England. And so what we say is important, and I won't go through it in detail, but at page 393, the court draws the distinction between you can be too narrow or you can be too wide. Narrowness is characterising the dispute by reference to a specific relief that only the English court can grant. Overly wide is identifying it in such a way that it's a different kind of right from that to be tried in England, or different underlying facts. And what we say, in essence, is that in order to strike the right balance between these narrow and wide formulations, the right way to characterise this dispute is a claim for breach of the negative covenant not to arbitrate elsewhere in breach of contract, for which appropriate relief is sought, or alternatively, it is a claim for breach of the negative covenant for which injunctive relief is sought. But if you pose the question in that way, and that, if you look at it in due course in the core bundle, there is the amended claim form, and we respectfully suggest that that reflects the way in which the claim form is identified, although that shouldn't limit the characterisation. And if you frame it in that way, which we say is the appropriate way and the way that the judge did it, then the question is not, can this specific relief be obtained from this court, but can any relief that delivers substantial justice be claimed from this court? My Lord, the only other point that I wanted to make is in relation to final relief. And there's not really very much that I wish to add about that, save to recapitulate the points that since the judge did not make any order about final relief, only made an order about interim relief, the appropriate course is to remit. Now, if my learned friend has got a good point about the need for urgency, then no doubt that can be done urgently. But what I would resist is simply accepting on assertion that the issue has to be dealt with now. The second point is that with the three additional points that we have raised that go to the separate discretionary question about final relief, my learned friend dismisses them, but they do in fact have to be heard and resolved at some point, and they depend on evidence.
That would be a trial of how long?
A day.
A commercial court.
A day.
You say a day's trial is required in a commercial court.
My Lord, the other point, and I promise this is my last point, it's important to think about comity. And what my learned friend submitted, as I understand it, is that, well, because the French court doesn't have a philosophical objection, that removes all questions about comity. Now, in our submission, it does not, because there is a difference between making an ASI that the French court will enforce, and in order for this court to determine that it has the jurisdiction to make the ASI in the first place, this court has to draw an adverse comparison to the quality of justice that is capable of being provided by the French legal system. And there is no escaping that judgment as a part of this exercise, because there is no escaping the fact that the conclusion is that the French legal system is unable to provide substantial justice, because that's a necessary aspect, because it does not offer the remedy of an ASI. And we do say that would be a very striking thing for this court to conclude, which it has never concluded in respect of the French legal system at any time before, and would be a surprising one in circumstances where this jurisdiction is in a distinct minority in offering anti-suit injunctions, and therefore to conclude that substantial justice could not be obtained because of the French court's deficiencies in that regard would, in my submission, offend comity. My Lords, unless I can assist your Lordships further, and I apologise for going on even beyond my 5-minute additional
Quite all right. We'll rise for a few minutes and decide where we go from here.